Tomorrow, the Supreme Court will hear arguments over a trademark dispute between whiskey company Jack Daniels and a dog toy company. The case could redefine how the court applies constitutional free speech rights to trademark law. And it stems from a dog toy. It's shaped like a Jack Daniels whiskey bottle, and you can read on the label for yourself. Jack Daniels says the toy is bad for its business, and it's asking the Supreme Court to reject a lower court's ruling protecting the fuzzy, squeaky, bad spaniel dog toy. Joining us now, trial attorney and legal analyst Misty Marris. Good to see you, as always. So this is a trademark infringement dispute, right? Is there any precedent for this?
There absolutely is. So there's what's called the Rogers test. And this is the test that was actually applied by the Ninth Circuit, which is the lower court, that the Supreme Court is going to be looking at that ruling. The Rogers test says that a company can use a trademark without authorization so long as there is, number one, artistic expression in the way that it's used. So in this case, we're going to be looking at whether or not this qualifies as parody. And number two, that it does not explicitly mislead the consumer. Now, this is a test that was out of the Second Circuit in 1989. And there's actually been a lot of fodder about whether or not this test is actually too all-encompassing and goes too far. It sought to balance interests between First Amendment and trademark infringement, and there's actually some other cases in lower courts that were looking at the application of this standard. So the Supreme Court weighing in on this, everybody thinks it's crazy. I had a ton of people asking me, how can anybody be confused? This is a dog toy versus liquor. But the implications of this case are actually very far reaching to the extent that that standard is changed or potentially limited in its use.
Right. So Jack Daniels is basically saying this dog toy hurts our brand, which VIP products from Bad Spaniels, the dog toy, says this was a joke. It was a parody. I guess the question is, did VIP profit from the joke, right? Will the justices be trying to determine that?
They're going to be looking at the profit. They're going to be looking at the critical question here, and this is what the Jack Daniels wants them to look at, whether or not the Rogers test should have even applied. If it shouldn't have applied, then there's been an argument that this should not apply to commercial work. It should only apply to movies, books, music, those types of artistic expression. So that's one question that the court is looking at. And Jack Daniels has made the argument that, again, nobody's trying to drink, liquor out of the dog toy. That's not where the confusion is. It's that their brand has specifically tried to be responsible in advertising, underage drinking, a whole host of concerns when you have an alcohol company, and that this dog toy could actually dilute the goodwill of their brand and create confusion. Liquor and children don't go well together, and liquor and excrement don't go well together. That's actually a quote from one of the briefs. I do want to say there's a case from 2007, the Fourth Circuit, so a different circuit than this came out of, relating to a brand called How Diggity Dog. And they created something called the Chewy baton.
I have it, Misty. I was going to ask you. My dog has a Chewy baton. Go on my Instagram. I have a picture of her. She's got her little purse in her mouth. So what happens?
So,
do I lose the Chewy baton?
Oh my gosh, the Chewy baton. Yes, we've all seen it. Super cute. And the Fourth Circuit back in 2007, said this is so clearly parody and found in favor of the dog toy company. So that's something that's out there. The one thing that case didn't address, and that's really the most on point case with this particular issue. The one thing it didn't address is the First Amendment issue. So it didn't go that far as to talk about the First Amendment. It just said that this is a parody. Louis Vuitton doesn't make dog toys, so there's no competition, and so there was not any infringement. So it'll be interesting to see how this plays out. I hope you get to keep that Chewy Vuitton toy. I've seen that. It's adorable.
It is adorable, and I mean, half of it's torn anyways. Nobody's going to want it. Nike and Campbell Soup apparently filed briefs in support of Jack Daniels. We'll see if that carries any weight. This is one we'll be watching that wasn't on our radar, but I'm glad it is. Trial attorney, legal analyst Misty Marris, thank you for that and for the smiles this morning. Good to see you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.